His prior criminal record, she has none. Defendant's record of appearance and non-appearance or flight to avoid prosecution. She's been at everything. She's actually been at more.
Well, that flight issue also includes concealment of evidence, doesn't it?
And I guess this came up at the bench when we were here on, surprisingly, on 2/28 or 2/20, our last probable cause conference date, 2/22, when neither party had asked to address bond, but you had mentioned it.
Well, counsel, if you want to point at me, I'll tell you exactly what I know about this case. What I know about this case is the warrants came to me. That's how I knew. And that it came to me because I'm in charge of all of these felonies and reviewing every bond that comes through. So that's how it came to me. So if you want to make dispersions against the court, go for it. Let's roll.
I'm not making dispersions. I'm saying the court had asked us to approach and talked about bond.
Because I'm putting everybody on notice where I am. That's why. Go ahead. You want to come at me? Let's do it.
I'm making a record as to.
No, go ahead and make your record. I'm just telling you where I am.
In addition, and obviously we know that search warrants aren't necessarily evidence. I appreciate that you know things or allege things because you were a party to the search warrants. In addition to what I've already indicated in terms of bond, she's not a flight risk. She's appeared at every court appearance. She's gone to the sheriff's department, met with Detective Webb. She consented to a release of and a search of her phone. She doesn't have any shown history of substance abuse or addiction, a mental condition. She's employed thankfully at a local hospital. She's got family members here. She's probably got about 5 family members here. She lives locally. She's got ties to the community. Again, bond is set at protecting the community and a flight risk. I think that what she has shown over the course of the past 2 months is she's neither. I'd ask that bond stay the same. Thank you.
From the people.
Nothing further, Your Honor. Thank you.
The court, in looking at the file and so that the record is clear, counsel came to the bench and the court was apprising counsel that the court had some concerns with the bond that was set. Neither counsel at that time was ready to raise the bond. There were certain things that came to the court's attention that were not in the magistrate's mind nor the magistrate's information at the time of the arraignment. I brought that to counsel's attention, quite frankly, out of fairness to both sides so that it could properly be argued before the court. What was not known, certainly to the magistrate at the time, was that there was this delay. There was information that was provided to the magistrate at the time regarding the defendant turning herself in, which was somewhat confusing as to how that occurred. And I apprised counsel of that. What my initial conclusion or what I saw was based upon what was presented to me prior to that hearing. Additionally, since that time, something that was not available to the magistrate were these text messages, which lead also to the defendant's knowledge, which play into this court's mind as to this defendant's danger to the public. Furthermore, there is, in terms of the issue of flight, of concealment of evidence and the like, now the deletion of text messages and other evidence in this case, which have just been alluded to, the deletion of basically evidence, which I think also bears upon the defendant's risk in this case. Also, the likelihood, the court can take into account the likelihood of conviction and other things as it regards to setting a bond. But certainly there is now clearly more information that's available to the court regarding this defendant, the offense that was committed and the like. The court, I will also take into account the fact that I don't have any community corrections violations. I don't have anything along those lines. I do not believe that, given the information now available to the court, that the amount of the bond that was originally set, I do not believe that it is appropriate. and that additional bond would be required in this case. Defendant's bond, Mr. Allen. The defendant's bond in this case will be increased. I think that the amount requested by the people was an appropriate amount. Quite frankly, it was appropriate, but now knowing what I know, I would actually raise it beyond that, but I will not do so. In this case, her bond will be increased from 50,000 cash surety to $100,000 cash surety. Are they, counsel, just for the purposes of anything, are they able to do that right now, or?
We've made arrangements. There's a surety bondsman in the courtroom who can do that. If you can give us 15 to 20 minutes, it'll be taken care of.
She'll be taken back and do that. I think they can do that.
Hold on, sorry guys. We need to arraign her on the information. I apologize. I interrupted all of our proceedings.
Oh, okay. Yes, that's to the circuit court.
We'd waive the reading of the complaint and have the matter set for circuit court pretrial. I asked that she'd stay.
She stands. Defendant having waived from a reading standing mute, the court will enter a not guilty plea. Pretrial, technically, counsel, and I'll do it for the convenience of your schedule. Technically, she would be given the end date, but if it looks like you're going to post, I can give the out date. So
Yeah, she'll be out.
She'll be out.
May 2nd at 1:30 before Slate Thursday.
Pretrial May 2nd, 2024, 1:30 before, that's a Slay Monday, Slay Thursday.
Judge, after that surety is posted, can I come back with proof so that, please?
Thank you. Hold there.
There.
The jail is right. Court does call the case of the people versus Jaylon Johnson.
Julian appearing on behalf of Mr. Johnson. Your Honor, so we are still continuing with discovery. Mr. Johnson and I need to do a thorough review of everything that we have. I am requesting, unfortunately, I'm in trial 4 weeks from today, so I'm requesting either 3 weeks or 5 weeks for an adjournment.
18th. Probable cause conference will be adjourned April 18th, 2024, 9 a.m. Bond continued.
Thank you very much, Your Honor.
Thank you. Court does call the case people versus Kevin Sullivan.
Good morning, Your Honor. Christina Costantino appearing on behalf of Mr. Sullivan. Your Honor, it's an interesting story about Mr. Sullivan and his whereabouts.
Oh boy.
I'll tell you that.
Okay, go ahead.
Very interesting. I received a phone call. Well, actually, he was not present in your courtroom, and I called him at about 9:30 to determine his whereabouts. He was in the back of a Royal Oak police vehicle.
Is in the back of what?
A Royal Oak police vehicle. And I did speak to a very kind Royal Oak police officer who informed me he would not be able to make it to court today because he was in the current custody of Royal Oak Police.
So they weren't bringing him here.
No,
Oh,
Judge,
okay.
no.
All right,
They
go ahead.
weren't. They were kind, but they weren't that
That
kind.
kind. Okay.
So, Judge, given that, I'd ask for an adjournment of the PCC.
Did they tell you where I should send the writ?
Yeah, I mean, that's.
They didn't provide me with that
They
information.
did not.
They did not. And I don't know if they quite knew exactly where he was going to be held or for how long. But I'm happy to follow up with that. It's an evolving situation.
People are requesting a bench warrant.
Yeah, I know. Okay, so
And he was just in court last week on this, Your Honor. And as far as I know, I don't believe he's missed any prior court dates.
you missed something.
Something somewhere.
Something somewhere.
I don't, not here though.
Yeah, but not here. Here's what I'll do, counsel. I mean, I appreciated the story. So I would almost give the adjournment, but we're not going to know where he is.
Yeah.
So what I'm going to do is I will issue the bench warrant. I'll set his bond at 10,000 cash or surety. Once you figure out where he is, I don't have a problem dealing with that warrant in some way.
Thank you, Judge. And would you consider holding the warrant for 48 hours just so that if he is released today, we might be able to
So
bring
did
him
this
in?
friendly officer sound like they were going to let it go?
I don't know, Judge.
Yeah, yeah.
I'm not
But
sure, to be honest.
I don't
I
think they're
don't.
going to be that friendly. So here's what we'll do. I'm going to have the warrant issue immediately. However, if you discover that he's been released, there's a procedure here where we can set that
Just set it aside. Okay, yep.
Okay.
Thank you, Judge.
Thank you for the story.
Anytime. Thought it brightened their day, like,
No, it did lighten my day. I thought only weird things happened to Julian. Court calls the case, People versus Gary Moore.
Erica Julian, appearing on behalf of Gary Moore. Gary, can you state your name for the record? Mr. Honor, we are requesting adjournment. I have a referral for screening for the mental health court. And it requires the court's signature.
Yes, it does.
Okay. And that's what we're seeking to do. There's a misdemeanor offer in the event that he's eligible for mental health court. And so we're wanting to have him screened so that the people know for sure whether they can truly extend that offer.
How long are they running? Do you know?
I don't know the answer to that, Judge. So
I had put you out to the 18th before, right? Why don't
Yes.
we just do that?
that sounds great, Your Honor.
Probable cause, April 18th, 2024, 9 a.m. Bond will continue.
Thank you very much, Your Honor. You're all set.
Court calls case, People versus Corey Bird.
Assistant Prosecuting Attorney Morgan Barroso.
Good morning, Your Honor. Matthew Mansour, Assistant Public Defender, on behalf of Mr. Corey Bird, who appears today via Zoom.
Bird, can you state your name, please?
Corey Bird.
Thank you.
Thank you, Your Honor, and thank you for allowing him to appear on Zoom. I'm going to request a 1-week adjournment here to allow the victim advocates additional time to speak with the victims about the restitution amount.
Your Honor, we have been having ongoing conversations. There's a substantial amount of restitution being requested in this case. The first number that we received was $90,500. That number has gone down. So we have not gotten an exact documentation in support of that request yet. The offer that has been extended for these 3 co-defendants is to waive up to circuit court and plead as charged under HIDA with an agreement to restitution, joint and severally liable for the 3 co-defendants in this case. But understandably, they are wanting to get a more in-depth understanding of what that restitution actually is. So at this time, the number we have today is closer to 70,000, but we still do not have all of the documentation in support of that. And I would like to give our victim advocate a little bit more time in order to get all of that together for defense.
Probable cause conference, April 18th, 2024, 9 a.m. Bond continued.
Thank you.
Mr. Hammoud, can you approach on a separate matter, please? Court calls